Welcome, everyone that is tuning in. We are so excited to be discussing copyright and intellectual property protection today. My name is Blair Breitenstein, also known as Blair Z on Instagram. I am a founding member of the American Influencer Council and a co-chair of the Arts and Culture Committee. Quickly explain a little bit further about what the American Influencer Council is really quick. So we are a group of creators that are trying to be a voice to kind of the influencer and creator community by sharing resources and being a sounding board, as well as creating transparency within the influencer and creator industry, and creating some industry standards as where we can, but really to also just be a resource by doing things like this Lunch and Learn today. And then with me today, I'll let the other panelists introduce themselves. So we could start with Katie.
I'm Katie Rogers, and I'm an artist, and I'm currently based in Santa Fe, New Mexico. And I'm also a co-chair of the Arts and Culture Committee at the American Influencer Council. And I'll let Kendra take over.
Hi, my name is Kendra Dandy. I'm an artist and illustrator based in Philadelphia, and I am an AIC founding member.
Hi, I'm Meredith Wing. I'm an illustrator and artist based in Brooklyn, New York. I'm a guest of the American Influencer Council, and I'm excited to be here to chat about copyright and digital rights.
Hey everyone, I'm Kevin Madigan. I'm a VP of Legal Policy and Copyright Council at the Copyright Alliance. And I'm delighted to join you all today to talk a little bit about some copyright issues.
Amazing. Thank you all so much for agreeing to have this discussion today. So as a little overview, we will be talking about digital copyright infringement and fair use. And we hope this will shed light on how protecting your intellectual property supports innovation and also creates financial protections for all different types of artists. And then also just a reminder that the American Influencer website has a resource tab where you can find the information that we discussed today on the website. So among other useful information for creators. A little bit of what we are going to be talking about today is what the Copyright Alliance is, which I'll have Kevin explain in just a second, what to do when your work is being used outside of the country, actions to take when someone else is trying to sell your work, figuring out what is copyrightable and what's not, which I'm really interested in, and a lot more. So at the end, we will also be able to take some questions. And Kevin, I'll let you explain a little bit more about what the Copyright Alliance is, because it is a really useful resource for artists.
Absolutely. So the Copyright Alliance is the unified voice of the copyright community. We represent the interests of thousands of individuals and organizations across the spectrum of copyright disciplines. We represent the interests of authors, photographers, performers, artists, software developers, musicians, journalists, songwriters, video game designers, and many other individual creators. Pretty much any form of art or creative expression, we represent people involved in them. We also represent the interests of copyright owners in areas of art or industries that are not as obvious, like architecture and fashion and design, or groups that produce model safety codes like the National Fire Protection Association.
We have a lot of questions to ask you, so I think we can kind of dive into that. If Katie, you want to start us out with the questions?
Thanks, Kevin. We wanted to start by asking, what steps does a creator need to take if another artist sells copies of your work to a brand?
Sure. So one of the first things to consider is whether you've registered your work, because while copyright protection exists automatically from the time of creation and fixation of a work, registering your work will allow you to enforce it through a lawsuit and possibly get damages if you prevail. Registration fees vary, but it's $45 for a single work. And you can also register works in groups for a little higher costs. So for instance, photographers can register up to 750 works in one registration for a fee of $85. Registering a work is really beneficial, not only because you can sue an infringer if you have to, but it also creates a record of the work within the Copyright Office so that people can search and find out who owns the work for licensing purposes. So I would encourage everyone to register your work if you can.
So
oh, go ahead.
Just to be clear for everyone, so if this happens and I find out someone's using my work, I can then go and copyright or register my work after I find this out still. You don't have to do it beforehand.
Yes, but you have a limited time. So if you find out someone's infringing your work, you need to register within 3 months of finding out that infringement to be able to file a lawsuit. So,
Okay.
So if you have an unregistered work and you find out it's being infringed, then I'd suggest registering it as soon as possible after that.
Okay. And then a follow-up question to that is, what recourse can creators take when plagiarism occurs outside the US? If another artist in another country repurposed my work, is there anything that I can do internationally?
Yeah, so this can be sort of a tricky situation depending on the circumstances. So you first need to think about whether you've registered your copyright and then exactly sort of what this repurposed use of the work is. Sometimes if someone repurposes a use, it could fall under the fair use doctrine if they've used it in a certain way. But if you've established that it's not fair use or subject to other limitations and exceptions to copyright, then you need to consider whether the brand that's using your work without permission has any contacts within the United States. And by that I mean, are they selling your work on like a US-based website like Amazon, or do they have offices or a presence in the United States? If they do, they would be considered to have something called certain minimum contacts in the United States, which would subject them to US jurisdictions, which means they could be sued in the United States.
I see.
Now, if they don't have any contacts in the US, then you could try to determine what country they're in, because many countries are members of intellectual property treaties that provide the same type of protections that copyright owners have in the US. There's something called national treatment, which applies when your country and the infringer's country are both signed on to the same international copyright treaty. And then the treaty member awards other country members the same protections that the country would award its own citizens. But ultimately, even if the infringement is occurring in a country that's a member to one of these treaties, if they have no contacts within the United States, you might have to think about contacting an attorney in that country to help you try to stop the infringement or initiate an infringement lawsuit.
Okay. And one last part to that is someone's asking, what do you mean when you say register your work?
Sure. So registering your work means filing an application with the Copyright Office. So it's really simple. You can go to the Copyright Office website. They have the forms in a very easy to locate location on their website. And basically, if it's a photograph or a work of visual art, you can upload just a copy of that to the website along with your application and the fee, which is $45 per single work. And what they do then is the Copyright Office will review that application to determine that it meets the standards for copyrightability, which I should mention are very low. As long as something is sufficiently original, it rises to the level of copyright protection. And then you get a registration certificate. Usually it depends sort of on how many works you're registering, but back before I was a lawyer and I was an artist, I think I got my registrations within about 3 weeks for some works of visual arts.
I have a follow-up question to that. So for like registering the artwork, potentially would someone register every single drawing that they share publicly for protection?
You could, but there are ways to register in groups, because the Copyright Office realizes that it doesn't make sense for someone who produces a lot of works, like let's say a photographer who, could shoot hundreds or thousands of pictures over the course of a few days or an event. So there are options of group registrations for works. I think for photography, you can register up to 750 photographs in one single registration. You have to pay a little bit more for it, but you don't have to do one separate application for each work.
And that would also probably be like the same one-time fee for like the 700 works?
That's right. I think it's $85 fee for a group registration of up to 750 works.
Wow, that's really cool. So I also just want to remind people that you can find this information on the website when we're done talking about it, because it's like a lot to take in, but really, really helpful. I personally have not registered my work, which is kind of mind-blowing after being an artist for 6 years. So just a reminder that you can find the information on the website when we're done. Kendra, I know that you speak openly on your Instagram about plagiarism or like borrowing your work or getting inspiration from your work. I'm curious to hear what questions you have for Kevin.
Yeah, so I have a lot of people who take inspiration from my work and they profit off of it. What do you do if someone plagiarizes your work? I know it's one thing if somebody just straight up like copy pastes your work on something, but what if it's more of a plagiarizing situation where it's really similar but not like cut paste, and like what are the steps do you take to do something about that?
Right. So I should just first of all say that copyright infringement and plagiarism are two different things. Plagiarism has to do with the written word. So plagiarism is more like when you copy an essay in college or something. Copyright is more of our expertise. So, but I think I know what you're talking about when someone, takes inspiration from you. But so again, you have to ask yourself the similar questions that I talked about earlier. Do you have a registered work? You don't have to, but I'm saying it helps if you want to eventually try to stop that person if they're profiting from your work. But the other thing you want to consider, before maybe considering doing something drastic like filing a lawsuit, is consider whether what they're doing qualifies as fair use. Fair use is this 4-factor test that basically courts use to analyze whether a use of a work is permissible. And the factors include things like the purpose and character of the use, which means is it for commercial or non-profit purposes, or whether it's for an educational use. Now that doesn't always mean it's going to be fair use and you have no recourse, but a lot of the times if someone is using your work for a purely educational purpose and they're not profiting from it, that's going to weigh in favor of fair use. Now the second fair use factor takes into consideration whether a work is fictional, which weighs against fair use, or whether it's factual, which weighs in favor of fair use. And then another thing that's taken into consideration is whether a work is published versus unpublished. If something's unpublished and someone's taken it, if you have an unpublished work and someone's taken and used it, that's going to weigh against fair use. The third factor is the amount that someone takes. So this can be like a quantitative question, meaning have they taken a large amount of your work or just a little bit? If they take the whole thing or 95% of your work, that's going to weigh against finding a fair use. But if they use like a tiny little corner of a photograph or a painting and use that in like a bigger collage of theirs, that's probably going to weigh more towards fair use. But it's not always cut and dry, because there's something known as taking the heart of the work. And that means taking a piece of the content that's sort of the most important part. I guess an example that comes from a famous case is there was a book, a memoir written by former President Gerald Ford, where, it's this whatever 300-page book. And then there's these couple pages on when he pardoned President Nixon, which was basically like the juiciest part of the book. And that's why everyone was buying it. And so a magazine took those couple pages and reproduced it in a news story. And even though that was only a tiny, tiny fraction of the entire work, that was found not to be fair use because it was the heart of the work. And then the final fair use factor that you need to consider is the effect of the use on the potential market for the copyrighted work. And that basically means if the person has taken some of your work and without permission and used it in theirs and is selling it for profit, are they taking away a potential market that would have been yours? Like, are people buying this other work instead of your work? And that's a very important factor. And if that can be shown, then that weighs heavily in favor of you and against fair use. But there are some other ways you can sort of combat infringement. And one thing I wanted to mention was that if a person is using a platform to try to copy or distribute your work, so let's say they've taken your work and they're redistributing, or they've reposted it on YouTube or Facebook or Instagram or something, you can send what's known as a DMCA takedown notice. DMCA stands for the Digital Millennium Copyright Act. And basically, every major platform is required to make available these forms on their websites that you can fill out. You don't need a lawyer to do this, but you basically fill out this form and you point them to where this infringement is occurring and tell them that you're the copyright owner, and they are required by law to take down that content. Now, the person who originally posted it does have the opportunity to respond to that takedown and claim fair use or try to say that you're not the actual copyright owner. But if they don't do that, then that content will have to stay down. So those are just a few of the ways that you can go about, combating infringement online.
Kevin, I just had a follow-up question to that. When you say publication of an image previously as being something that would support or go against fair use later, can a social media platform like Instagram be considered an arena for publication, or are we talking like conventional magazine editorial works of art? Yeah.
So it's a bit of an unsettled issue. So publishing something basically means you've offered it to the public for sale or licensing. So if you're using Instagram just to post pictures of your work, but you're not offering them to the public to license them for anything or to sell them, that probably wouldn't count as a publication. And in which case, you're going to be able to, that's going to weigh more in favor of you and against fair use. But if you have a website where you sell your work regularly and you post something there for sale to the public, that's going to be in the as a publication. But that doesn't mean that if someone takes it, it's automatically fair use. That's just one factor that's considered alongside the other three.
Okay, so I have a follow-up question with everything we were talking about with the percentages and like what may be considered the heart of the work. So a lot of people have said that if you change the original artwork by a certain percent, like just enough, then everything is fair game. Like all you have to do is change it by 20% or whatever. Is there any truth in that? And can people escape copyright issues by just changing it by a certain percent?
Yeah, so that's definitely a misconception, and that's not true. There's no like magic number or percentage or amount of change of work that puts someone in the clear. It really all depends on the fair use analysis and the four factors I talked about earlier. And most applicable to this question would be that third factor, which looks to the amount or substantiability of the work taken. So if you incorporate a small amount of a pre-existing work into your work, it may weigh in favor of fair use. I used that collage example earlier. If you use 10% of an existing photo in a giant collage that has millions of different pieces of art, that's most likely going to be considered fair use. But you have to be careful because, again, what I talked about, the heart of the work, it's if it comes down to the most recognizable portion of a book or a video or a painting, for that matter, that's sort of, again, that's the part of the work that everyone recognizes. And so if you take that and incorporate it into your own work, it's not gonna bode well for you.
So does this go back to plagiarism versus copyright? If there was a t-shirt with a graphic on it that looks exactly like my graphic, but someone else drew it and gave it to the brand, does that make sense? Is that copyright infringement or no, because someone else redrew my work and then gave it to the brand? Or is that plagiarism, or what is that? Is there a term for that? And can those people be held responsible? Yeah.
Sure. So certainly, no, that's definitely a copyright issue. It doesn't matter if someone else retraces your image or somehow produces it in another way. If someone takes a photograph and changes, reprints it, but changes the colors in it or something, but it's the same exact photograph, that's almost always going to be copyright infringement. If I, sort of re-stencil over someone else's drawing, it doesn't matter that I've created something new, as long as I've, if it's not an original work to me, that would be considered a derivative work, which is one of the rights of a copyright owner, and you would certainly have a claim for copyright infringement.
That is super interesting, and that's what Kendra, I think, was saying too, about just changing. If someone takes her a picture of her lipstick and then adds a smiley face on top of it, it's still her work. They did not change it enough, and that is copyright infringement. Okay, cool. Kendra, did you have any more questions to add to that?
No, I think that was my main question. So.
Okay, cool. So I have more questions that are related to style and copywriting style, which is very confusing to me. So is it possible to do the register a style, I guess? So for example, if I always draw the same eyes and lips on all of the girls I draw women, and that's kind of my style, can I register a style?
So a drawing style, the short answer is no. So copyright protects not ideas or styles or genres, it protects the expression of those things. So a style or method of drawing or painting or even writing, or a style of photography would not be protectable by copyright. And the reason is because copyright is not only protects work of expression, but it also is meant to allow others to build on sort of the underlying ideas under those expressions. So for instance, you can't copyright an idea or genre of a mystery novel or a romance novel, even though you can certainly copyright a specific book that represents an individual's expression of that genre. Similarly, you can't copyright a drawing style that, let's say, incorporates like cartoon-like characters or something, or a drawing style that uses certain pencil strokes. Because if you could, that basically means it would allow you to exclude others from ever using that to create other original works, simply because they involve a similar drawing style. And that's just not what we want. As a society, we don't want to hinder the creation of more works. Now, I should mention there does exist intellectual property protection for certain methods or processes or ways of doing something, and that's patent protection. But to rise to the level of patent protection, the method would have to be what's known as novel and non-obvious, which I think would be very difficult for a style of drawing to rise to that level, to get a patent on a style of drawing. So I guess in short, it's really not possible to own an artistic technique. And again, that's because our copyright system wants to encourage the creation of artistic works as much as possible, and allowing someone to stop someone else from using a technique would really stifle the creation of new works.
So this is just like a cheeky question, I guess. There's that quote about like copying being like the sincerest form of flattery, or and different words maybe, but I was just wondering how you feel about that quote.
Well, I think that quote, there's a lot of truth to it, because if you look really at any genre of the arts, but I'll just use music because it's probably the easiest example. In a way, everyone builds on what's come before them. There's only so many notes in music. So what's been done before is going to be done again. It's inevitable. I think there's an older quote from a classical artist that talks about, how basically everything is stolen from the classical masters in some way or another. And when you're like I said, when you're dealing with just a finite amount of notes, it's inevitable that people are going to, even if they don't mean to, they're going to write the same chord progressions and songs over and over again. And that's sort of one of the difficulties of copyright infringement suits when it comes to songs, is that it really comes down to asking a jury whether these two things are substantially similar enough to constitute true infringement. And there's cases that I have come down the total opposite way of what I think. I say, I don't think those two things sound too similar enough. And there's others where I'm like, oh, those definitely sound similar, but a jury finds differently. So it's really this case by case basis. But I think, there's a lot of truth to that quote that you said, and it doesn't matter the genre, there's going to be people building on the artistic expression of what came before them. It's just a matter of trying to draw the line somewhere to say, hey, okay, this time you took too much, and that's sort of not something that we want to encourage in our copyright system.
Yeah. Okay, so I have another question, which is it's specific to me, but would be useful for others. So a lot of my drawings are inspired by fashion campaigns, I guess. And so I'll draw a girl on the runway wearing a sweater that has like a logo on it. So maybe it's like I'm drawing a Chanel fashion show, and one of the pieces has like the Chanel symbol. Is that allowed, or what's the Chanel logo is obviously copyrighted, but or if you're drawing a still life maybe of like an alcohol bottle that is Bombay Sapphire and it's a still life, can you sort of like explain the protocol for that?
Sure. So it's actually a trademark issue, not copyright, because you can't copyright a name or a short phrase like Prada or Absolute Vodka or whatever. But so basically, what you need to consider, so trademark law is all about whether there's a likelihood of confusion as to the source mark, as to the Prada name. So for example, if you're using the name Prada, if you're making purses or clothing and you're using the name Prada on those purses or clothing, then that's, people are likely going to think that that's made by Prada, or they at least, endorse the product in some way. And so that would almost certainly be trademark infringement. But if you're using the Prada name in an artistically relevant way, in like a painting or a drawing in your case, that doesn't sort of mislead to the source, then you're going to have a better chance of not being held liable for trademark infringement. For the same reason you could use the Prada in a song. I'm sure there's plenty of hip hop songs that talk about Prada, and you could use Prada in a book, talking about a character who buys something made by Prada, and that's not likely to be confused as something that's that Prada is the source of. So that would be that would almost certainly be allowed. Although I'm a disclaimer, I'm not a trademark expert, so I'm going back to like my law school class where they taught me this stuff years ago. But you could also use Prada in like a work if it's done for purposes of like a parody or a critique, which is something you can also do in copyright. However, there's one thing I should mention, and that's this legal concept of tarnishment. And that applies when a trademark is used like alongside like offensive content, like, I don't know, sex or drugs or other graphic themes. The trademark owner could argue that the trademark was tarnished by this use. And the term essentially means that a consumer might negatively associate your offensive Prada painting or drawing with the Prada brand. And so that's something you would definitely want to consider if you were creating a piece of art that incorporated a brand name logo.
Cool, that's really interesting. And kind of like maybe provide some relief. Meredith, go for it.
No, I was just to piggyback on that because it's relevant to me also, and I realize you're copyright and not trademark expertise, but does the commercial resale of those images in the form of prints online like Blair and I do, does that complicate anything in terms of like recourse that the brand might have, or is it sort of just as likely that a Chanel would come after two illustrators as it would be if they shared that image on their Instagram?
Yeah, again, don't quote me.
Not your area. Yeah.
I think if I guess it would depend on who the market is that you're selling these to. So if it's people that might think that these drawings were produced by people working for Prada or Chanel, then I think that's a problem. But yeah, again, not a trademark expert, sorry.
Okay. That's okay, just curious.
And also that if it's not competitive with, like you said, kind of what they're selling, it's like it's not really maybe a problem if it's not like competitive, sort of.
Yeah, I don't know if competitive is the right word, but if there's the likelihood of confusion, I think, is the big part of trademark. So
Got it.
If people are not confused at all to whether the Prada or Chanel is affiliated or is the source of the work, then I think you're pretty much usually in the clear for trademark. So if you're painting a painting where the person so happens to be carrying a Prada bag or something, that's going to be sort of a different artistic purpose. But I'm sort of hesitant to go further than this because I don't want to give people wrong information.
Totally. cool. Okay. Meredith, do you have any other questions about IP? Maybe?
No, not specifically on that. I realize that it's digressing a little bit, so we can stay on topic.
Okay, cool.
I have one question for him that kind of piggybacks on one of the earlier questions that I asked. But so I had a specific situation where an independent artist took my work and basically redrew it the same. And they then went on to sell that work to multiple like global companies that are really huge. My question is, when I did reach out through a pro bono lawyer to the artist and the brand, the artist said, you know, I didn't copy your work, blah, blah, blah. Anyway, we have proof of it and everything. And then I reach out to the brand and the brand doesn't respond. And in order to do anything about that, I would need to spend so much money beyond what I am able to do to even tackle that in any way. And I think that's a big issue with artists that are smaller is you don't know how to approach these situations because at the end of the day, it is a big expense. So what are your thoughts on a situation like that where people just ignore your cease and desist or anything like that?
Yeah, it's, unfortunately, I think it happens a lot. And, the last, resort is to hire an attorney and to sue in federal court, which can be very expensive and also time consuming. But one thing and thank you for the question, because I definitely wanted to bring this up, was one thing that's going to be happening very soon is that this small claims court is going to be set up within the Copyright Office. So late last year, this bill was passed called the CASE Act, which stands for the Copyright Alternative and Small Claims Enforcement Act. It was something we were very involved with at the Copyright Alliance, and we helped get passed. But what it does is it establishes this small claims court within the Copyright Office to hear cases from individual creators and small businesses who often don't have the resources to hire a lawyer and sue in federal court. And so it really provides this affordable and streamlined process for folks to enforce their rights. And there's actually a lot of other benefits for it too. You don't have to have a lawyer. It'll be done all virtually. And that's actually set to take effect and be completely up and operational in December of this year. So while it's not an option right now, it will be very soon. And yeah, we're really proud of the work we did to get that up and going. And we're looking forward to the seeing all the individual creators that are going to take advantage of it.
Correct me if I'm wrong, but kind of recapping everything we've talked about, the first thing we can do to kind of protect our work is to register it, is probably like the best first thing that we can do. And then from there, would you suggest first just like kindly asking someone to take down or stop reprinting your artwork? Or do you think that you should go with the DMCA? I don't remember if that's the right thing that you talked about. Or so after registering, what do you think is like the most important thing to do if someone is acting on copyright infringement?
Yeah, so I think before moving on to sending a DMCA takedown notice, if it's on a platform, or starting to consider whether you want to talk to a lawyer, is to consider whether there are any exceptions or limitations to your rights as a copyright owner, because fair use is the most sort of most commonly invoked defense to copyright infringement claims. there's a lot of misinformation out there though about what fair use is. I think, in this day and age where content is posted online so frequently, that people think, oh, this is fair use because I, changed one tiny or changed this amount in it, which is a misperception, or this is fair use because I'm not personally making money off of it. There's just a lot of misinformation out there. So I would suggest, if you want to know sort of more about fair use, we have a lot of resources on our website. And so, before you reach out to someone, you might want to look through the 4 factors and just do an assessment to yourself, because it might, if it's for an educational purpose and it's non-commercial and they've really only taken a tiny percentage of your work and it has no effect on the market for your work, then it might be fair use, and it might be a waste of your time to follow up on that. But if you have determined that it doesn't look like it's fair use, then see if it's appeared on a platform. If someone's selling something through Instagram or Amazon, that's when you can do the DMCA takedown notice. And then, sort of, or after, or before that, you could reach out to someone directly to ask them to stop. Unfortunately, because of all this misinformation out there, oftentimes people will brush you off and say, no, I have the right to do this or something. And that's when you might want to go the next step to like a takedown notice, and then, eventually sort of the last resort of either talking to a lawyer or making use of the copyright claims, small claims court when it's up and running.
If someone sold something with the photograph or drawing on it, and you know it's not fair, and you do the DMCA, can you receive compensation for what was already sold, or would that only come through a lawsuit?
No, that's a really good question. No, so you won't be. That the notice is really just to get the content taken down. In order to get compensation or damages, you're going to have to file a lawsuit or go through the Copyright Claims Board process.
Well, we have, I think, some questions in the group, in the chat, which someone has been typing answers to, but also do any of the panelists have any more questions before I move to, Meredith?
Yeah, I just had another question that was on the docket, but I was wondering if we want to have more conversations like these, and maybe this is appropriate for somewhere on the AIC website, but how can creatives with limited resources who don't want to, pay $600 an hour, how can we field questions to like certain forums, or are there any other sorts of like resources out there that would be useful? Perhaps peer groups, something like that.
Yeah, definitely. So I think, I mentioned earlier, our website has a number of resources that explain and answer questions on a number of copyright topics. Now, our website isn't interactive though. So, we try to, sometimes creators call us and we'll try to help them with questions. Although, I have to say that we can't offer purely legal advice. We also have a ton of resources on our website though that point creators in the right directions for some of the more complex copyright matters. We have something called our Creator Assistance Directory, and that lists free resources by state. And those resources primarily consist of things like legal clinics at law schools who do a lot of pro bono work, and also volunteer lawyer associations. So there's these things, VLAs, I'm sure some of you guys have heard of them, volunteer lawyers for the arts organizations. They operate in most major cities and in almost every state. And their mission is to provide free or low cost legal resources to the creator community. And then I also just mentioned our website has a find a copyright attorney database. that directs artists to copyright and intellectual property lawyers if it comes to that point and you need to talk to a lawyer. And then also, just finally, the last thing on that slide, the Copyright Office. So while they too can't provide legal advice, they do have web forms that you can fill out and they'll get back to you. And they also have a helpline where you can call and ask questions related to stuff like registrations and applications and things like that. And I should just put in another plug for our membership. So for individual creators, it's free to join as a member. And so we have a lot of stuff that's open, available to everyone on our website, but there's a few things that you only get by becoming a member. And that's things like you get access to something called our Copyright Academy videos. And that's where we interview copyright experts who will go in depth on specific topics. And then we also have like a weekly newsletter that would keep everyone apprised of anything that's going on in the copyright world, whether it's like a big court case that came down or an event of some kind. So I really encourage everyone to sign up as an individual creator member.
Great, thank you. That sounds great.
Yeah, that sounds like an amazing resource. And like, we're so grateful to have you speaking on this panel today to share everything that you did. And also I can't wait to learn more online. I know I definitely need help in the copyright department, and the first step seems kind of also like registering some stuff. So now I would like to, I'm just going through the chat, so sorry people, I'm reading to see if there's any questions that Kevin can answer. Let's see. Okay, well, while I'm trying to read some stuff, I guess I have another question.
Sure.
If you're working with a brand, would putting terms in an email, like maybe copyright terms or licensing terms in an email, like I'm allowing you to own the rights to this image for 1 year, would that hold up in court? Or I don't know, if you wanted someone to take something down after a year, would an email be valid?
I think it sort of depends, and you'll have to excuse me. I'm not a transactional lawyer, so I'm not sort of in the trenches of these kind of battles a lot. But I think it would sort of depend on whether they agreed. If they then, so it basically go to a question of whether it was an enforceable contract. So if you sent an email that said these are the terms of my contract, and they sent back an email that said we accept these terms, I think that could hold up. Basically because you need offer and acceptance for a contract. And so if you had those as proof of the agreement that they had agreed to the terms that you offered, I think that could be an enforceable contract.
Cool. Okay, this is going back to the chat, and it's something that we talked about much earlier, but for someone that is based in Europe and is working with a US brand, or should they register their work in the US and Europe, or commentary on that?
So I don't think they have to, but it probably couldn't hurt. So if they're in a country that's a member to one of our treaties, I think I mentioned they'll have national treatment and they will be afforded the same protections that we afford our copyright owners here. And if they have a valid registration, and I think most European countries are member to most of the international copyright treaties, that they wouldn't necessarily have to have a registration in both the United States and the foreign country.
Okay. And then do you know anything about Facebook owning anything that you post on Facebook, and I'm not sure if that's a copyright issue.
It sort of, it can be, I guess. So they don't necessarily own what you post on Facebook, but and this is an interesting thing that's coming up in with regard to Instagram lately. A lot of platforms now include in their terms of service something that says that they reserve the right to sublicense your work to a third party. And so basically there's been a few cases recently where someone posts something on Instagram, a photograph on Instagram, and then a third party takes it and embeds that photograph like in a news article, or it could be a promotional campaign. And so the law's a little unsettled here of whether that's allowed by law. You know, I know of one case where the court said, well, you agreed to these terms of services, so it's allowed. But I think most recently that case was just revived because a judge said that the terms of the language in the terms of service were not sufficiently clear as to what rights the Instagram had. But one thing I would say is just, if you are posting your work to one of these platforms, do read the terms of service and understand what exactly you're agreeing to when you sign up for an account. I do believe with Instagram, if you have a private account, they don't reserve the right to be able to sublicense your works. But if it's public, they're trying to claim that they do. So just be careful and read the terms of service.
Okay, and then I have another question from the group. This is interesting, specific to a screenplay, but anything, I guess, where you're pitching your artwork when it's in like the pitching phase. Is there a way to protect a screenplay while pitching during pitch season, such as Stage 22 or other screenplay platforms? And I would relate that to myself too. If you're pitching an illustration to a brand, can you protect work you're pitching?
Well, again, you know, make sure you've registered your copyright, and then I would say just sort of monitor what the person you're pitching to is doing, because I know there's been plenty of situations where someone makes a pitch for a screenplay and is denied, and then a movie gets made that's very similar to that screenplay. And so, you know, just make sure you're monitoring sort of what is happening with those people who maybe rejected your pitch, and if it comes to it, you might have to you know, file a lawsuit because they might have taken it without your permission.
Can you register? I don't know anything about writing. Can you register a screenplay?
Absolutely. Yeah.
And then that would be a conversation of how close it is to the original, which is the same thing with style and art-wise.
Yeah, exactly. Those cases usually come down to really how similar the two are. And, you know, people sometimes make claims, well, my script had the character of a police officer who's chasing a murderer or something, and that's not distinct enough to be protected by copyright. That's sort of something called scenes affair, you know, something that shows up in a lot of different genres. So you really, to prevail in a case like that, you have to show really specific similarities between the two works.
Got it. Okay, well, we're just about at an hour. I learned a lot today. Thank you so much for everyone that tuned in, and thank you panelists and Kevin and the Copyright Alliance. We will have this information on the American Influencer website, as well as information to the Copyright Alliance website, which has crazy, amazing resources for all different types of artists. So yes, I'm excited to share that information, and I hope everyone that tuned in learned a lot too. Yeah, so thank you, panelists. Any final words?
Thanks. Yeah, this was awesome.
Thanks for having me. And again, there's a lot of resources on our website, so please do check it out.
Yeah.
Thank you
oh my
so
God,
much. That was great.
so helpful. Okay, have a good weekend, everyone. Bye.
Thank you, Blair.
Thank you.
Bye.